the list. Please give. Number one. Hmm. Yes. Well, the matter has been released from the Honorable Acting Chief Justice Bench. Yes, let us see. কপিগুলো দিয়েছো? হ্যাঁ, আরে সে তো আমি তোমাকে দেখালাম এর আগে দিন, আমি তোমাকে তো বললাম, জাজমেন্টও দিলাম তো। ফার্স্ট চার্জেস সেকেন্ড চার্জেস গুলো একটু প্যারাগুলো বার করে। Yes. Well, the allegation against the applicant before the tribunal that he was appointed on the basis of a fake appointment letter. And for this reason, my lord, the first charge sheet was issued. And thereafter, my lord, due to there was some technicalities which was find out immediately after find out that when the first charge sheet, after withdrawing the first charge sheet, the second charge sheet was issued, my lord, with the reason. And while challenging that second charge sheet, the applicant filed the way number my lord, 718 of 2008 before the learned tribunal. And the learned tribunal, after a prolonged contested hearing, the application was dismissed. Challenging that order of the learned tribunal passed in way number 718 of 2008, they have preferred one writ petition before this honorable court. And the writ petition, after hearing the writ petition, my lord, that same was remanded before the tribunal again. My lord, in that respect, my lord, humble and respectful submission is that, my lord, that in the first way was dismissed. Then, my lord, that second charge sheet was upheld by the learned tribunal. And when, my lord, that was came before this honorable court, that there was no whispering regarding the second charge sheet. Regarding the second charge sheet. For this reason, my lord, my humble and respectful submission that the second charge sheet was upheld by both the tribunal as well as this honorable high court. And after hearing, after remanded, my lord, that writ petition was allowed. Initially, my lord, there was a difference of opinion in between the two honorable administrative member and the judicial member.
From the High Court's order passed in the earlier proceeding upholding the second charge memo.
Earlier order of
Yes, where does it say that the charge memo is upheld? So
yes, my lord, I'm coming, my lord. Just
no, a lot will turn on that. You said it was upheld by
yes,
the tribunal and the High Court.
Small facts, my lord, I want to place. And my lord, thereafter, my lord, due to difference of opinion in between the two learned judges of the tribunal, the same was sent before the third bench, my lord, single bench. And my lord, that was also, my lord, allowed the way, my lord. But my lord, kindly consider that according to the section 20.
No. First, you show us. You said in the first round of litigation, the second charge memo was upheld. Where in the High Court's order it says that the second charge memo is upheld?
Yes. Kindly come to the first page 36, my lord. First, my lord, order of suspension due to the fake.
Please show us from the High Court's order. Don't now go into unnecessary facts. We have understood.
Yes.
There is a charge memo, there is a second charge memo, and then he has raised an issue. You are saying that second charge memo was upheld up to the High Court. So show from the High Court. Then till that extent we did not look anything behind that. We'll proceed from there. We are not of the same impression that you are submitting.
My lord, page 94 of my thereafter. My lord, kindly come to the page 97, my lord. My lord, page 94, my lord, that is the order dated 3rd August 2012, my lord. The order of the Central Administrative Tribunal, Calcutta bench, that the petitioner challenged is that the charge sheet issued in him on 4th January 2006 was abandoned and the second charge sheet was issued on 20th October.
Why you are reading an interim order? We are asking you to show from the High Court. This is an interim order.
My lord, page 230, my lord. Kindly come to the, my lord, page 233 and on. The page 230, my lord, I am placing, my lord. The petitioner is aggrieved by the decision of the Central Administrative Tribunal, Calcutta bench in way number 7182 of 2008. The impugned order is dated 24 July 2012. The petitioner had challenged the charge sheet issued to him on 20th October 2006.
Come to page 234, last paragraph.
From the perusal of the order of the tribunal, we do not find that the tribunal has made any observation on the issue as to the whether the second charge sheet was issued to the petitioner without giving reasons for withdrawal on the first is valid. In fact, the tribunal has observed as such, it cannot be denied that the respondent have totally ignored the provision of the law and mentioned any reasons for withdrawing the first.
So tribunal has not upheld. You said tribunal upheld. Now High Court's finding. Come below that.
My lord, the tribunal was dismissed the first way, my lord.
Sir, this is a High Court record.
The petitioner
We'll rely on this, not on your submission.
No, my lord.
Please read again what you have just read.
The petitioner thereafter feels, however, it will be open for the petitioner to challenge the order of dismissal.
Yes.
Challenge the order of
Please
dismissal
read. Please read.
passed against him.
Yes.
The petitioner can raise all contention before the tribunal, including the issue as to whether that could have been issued.
Second charge sheet could have been issued. So neither tribunal nor High Court upheld the second charge. You said that both had upheld. In the penultimate paragraph, it says that the tribunal did not rule on this. In this paragraph, High Court says it is left open.
Why I am
You are saying both have affirmed.
Wonderful. Why I am saying the
why? What do you mean why? The facts are to be stated correctly. It is not a question of why I have said this. You see what is written by the High Court.
Yes, my lord. That second charge was open, my lord.
Yes, there was no confirmation by any forum.
Thereafter, matter was remanded.
Thereafter, matter was again taken up by the tribunal in a fresh proceeding.
Yes, my lord.
Then what happened before
the fresh proceedings, my lord? After hearing, my lord, both the honorable judges of the learned tribunal, there was a difference of opinion.
Yes.
For which matter was sent before the third bench. And my lord,
for what, sir? For what? What is the final order date of the tribunal?
Final order, my lord, they have set aside the.
What is the date?
Date of the
final order.
Yes. Date of the final order, my lord. On 11th of July 2023, my lord.
So that is the third judge's order.
Third bench. Last judge.
11 July 2023. And the charge sheeted employee died in 2013. After 10 years, what is to be done? That is the issue. Primary issue.
For a long time, matter was pending, my lord.
Sir, after the demise of the delinquent, so-called delinquent, what is to be done? What proceeding will now be conducted? You tell us.
And my lord, kindly consider that the petitioner, applicant before the tribunal, respondent herein, my lord, without preferring, my lord, the departmental appeal, and my lord, without exhausting the departmental formalities and procedure, my lord, directly filed.
All right, we set aside everything. You proceed against the dead person. You proceed. We are asking you a question. You are evading that question. You are making submission. We are asking you what is to be done now that he is no more. What you will do? Please tell us.
My humble and respectful submission is this: that my lord, that order of dismissal is, my lord, the good.
Good.
And my lord, without challenging the order of the disciplinary authority before the departmental appellate authority, they preferred, my lord, the application before the tribunal. And my lord, this is bar under section 20 of the Tribunals Act, my lord.
The charge sheet was set aside by the tribunal.
Charge sheet was set aside by the tribunal.
So if we allow your case today, that no, the charge sheet is valid, what will happen?
If, my lord, charge sheet is back, then definitely, my lord, the entire thing goes, my lord.
No, even if we say today that your charge sheet is valid, what you will do against the dead person?
And my lord,
this charge sheeted of employee has passed away in 2013. What you will do now? What is your instruction?
He has been died, my lord.
In 2013, we have seen, therefore we are asking.
And my lord, my humble and respectful submission is this, my lord, the section 20 of the Administrative Tribunal Act was not considered. My lord, consider 7 judges being.
Sir, we don't know what to
Yes,
say.
yes.
We
I have
don't know what to
understood,
say, how to react. What you will do, what are these submissions are worth, what for you, what relief you will get? You will proceed against him. You cannot.
No.
You cannot proceed against his family members.
No.
So that's what we are trying to understand. That's why we said the order of the tribunal is 10 years after his demise. Why you are pursuing the matter, we don't know. He cannot be dismissed today. There was an interim order throughout the first round of litigation. There was an interim order throughout the High Court proceeding. He continued.
Yes,
When
yes.
the interim order was vacated, what is the date? Prior to his demise, was the interim order ever vacated? Is there any window in between? Otherwise, we are wondering what you will get.
My lord, that was continued till the disposal of.
That's a very vital date. Therefore, we ask you. See, he has been dismissed on the basis of the second charge.
My lord, that writ petition was finally writ petition WPC number 253 of 2012 was finally disposed of on my lord 17th of September 2012.
2012.
Yes. And my lord, after remanding before the tribunal, person died.
Before the tribunal in the present round of litigation, in the last proceeding, also the punishment was stayed. Because he has died within 8 months thereafter. Perhaps sometime in June of 2013, if we are correct. We don't remember that.
After remanded my lord within 17 September 2012, and person died after few months, my lord.
No, but it was remanded or fresh proceeding was initiated. The old way was revived.
Was revived. So, my lord, the entire thing was challenged afresh, my lord.
So, in OA number 1381,
that is, my lord,
that is the original OA,
first way,
which upon remand was again considered.
Yes.
Now, in this
And
138,
first way number was, my lord, 1718 of 2008.
718 of 2008. So, this was a fresh OA.
This was a fresh.
After the High Court allowed him to
Yes.
challenge everything. Now, in OA 1381 of 2013, one vital aspect has to be seen whether there was any interim order directing that he should continue in service. If by virtue of an interim order he has continued,
No.
please be sure. Don't give a response just like that. Because throughout in OA 718 2008, there was a stay. In the earlier writ petition, also there was a stay. Throughout.
Yes, yes. I'm showing the orders, man.
So in the second round of litigation arising out of OA 1381, was there any stay or not? That we are asking. Earlier it was, we have seen already.
But in the first round of litigation, there was an order of the Planet Tribunal, page 37, last paragraph. The respondent, page 37, the respondents wanted to file reply. Reply be filed within 4 weeks. Rejoinder, if any, is to be filed within 3 weeks thereafter. Matter be placed before the registered court. However, there was an interim order. We direct that the respondent shall not impose any penalty till final decision of this regard.
Correct.
That is the first round of litigation.
That we are saying.
And that was continued till
That
my
was continued in the writ petition also.
Yes, first writ petition also.
So after the second OA was filed, was there any interim order? Did he continue till his date of demise, or he was not continued? That's the only thing we need to know. If he has continued, now what he will do?
কত?
You please find out. We will adjourn it for a day. You find out. You go through the records and find out. Please tell us. Two
the entire thing has been recorded.
So therefore, with that fact we'll see, and whether after such a fact there is any scope. These two things have to be seen. Next week, 14th, 14th August? No.
Yes, personal.
Yes.
My personal date.
Every date suggested by us carries some problem. Yes.
Kindly fix it at 12th.
Very well. 12th. Item number 2.
Item number 2, this is restoration application with some delay might due to due to compared circumstances of physical and medical problem of my mother. Due to compared circumstances of physical and medical problem of my mother, I did not appear at that time when the matter was called.
When it was dismissed.
It was dismissed on 23/8/23.
And what is the CAN number? Restoration is CAN number?
And number 1, This number 91 of 2015, 91 of 2025. It's still 91. Because 2000 typed wrong. So this was top, I think. This was top. This is the wrong order. In terms of uh, so, yeah, on the 9 2015. Remove it.
Yes, what is wrong with the tribunal's order? What is wrong with the tribunal's order?
Tribunal's order, my lord, dismissed my prayer of revising and refixing a pay scale. Being senior, I am getting lower pay scale than junior, my lord. So my grievance is this: being senior, I am getting lower pay scale than my juniors, violating the rule 55(4) of the West Bengal Service Rule Part 1. My lord.
Where is the GO of 12/10/98?
My lord, page 40, annexure C, 40.
40. So this is pursuant to The judgment passed by the High Court.
By passing this GO, my pay was revised and fixed, decreasing my pay scale, my lord. And my lord, can we come to page 47, Annexure G? Annexure G, page 47, on the last paragraph. A special officer to the special officer.
Where is the High Court's order? First shows the High Court's earlier order.
My lord, in this page, your lords will get that the SP has written.
First, show us the High Court's earlier order. We are asking you to show us the High Court's
Earlier order, my lord. Earlier order, page 35. 35, 12. 12, no, 34, 35, my 35. Page 35.
This is an interim order. Where is the final order?
This is final order, my lord. This is final order. Just to revise and fix the pay scale by Honorable Justice. This is the final order. Upon such order, this GO has been passed, my lord. Issued.
Writ was disposed of.
Right.
Where is it? Read. Where does it say writ petition is disposed of? Please read.
My lord, upon such order, the GO was issued, my lord. Whether it was passed, final order was passed or not, I am not aware.
You are not knowing. You are the petitioner and you are not knowing.
My lord,
Very good submission.
my lord, upon such, it may be interim order, my lord, but upon such interim order, the GO was issued.
So you are not required to tell us what happened in the writ petition.
Writ petition, my lord, I am only challenging the GO, my lord, by this.
What happened in the writ petition? You will file one after the other. We are asking you what happened in the writ petition. You say we don't know. Now you can say you don't know. You are the writ
Upon
petition.
such order, the division and fixation.
How many times you will say that? If you say it 4 times, it doesn't improve the situation. That you have already said that pursuant to the interim order, this was passed. GO. What happened in the writ petition? We are asking you. Where you have stated in the OA, what happened in that writ petition? And if that was pending, why you filed another OA? Tell us.
That is a very old matter, my lord.
Yes, it is your matter. It is not our matter. You are supposed to tell us. So it is old matter, so we should ignore all the facts and pass whatever order you want us to pass. That is your submission.
No, my lord.
Then what do you mean it's an old matter?
Actually, my lord, a new cause of action arises. And
We don't know whether it arises or false. Unless you show the final order, we don't know. And there's no way of knowing. If that is all, then we'll dispose it off right now. For the same thing, you will keep filing an OA and again a second OA. First, you will claim parity with one Rabindranath Rajan, then you will claim with reference to one Raghunandan Sharma. What happened in the earlier writ petition? You are not telling us, and you are saying fresh cause as a reason.
My lord, I have annexed a comparative pay statement, my lord, from where it reveals that I am getting lower pay scale. Still now, my grievances is this, my lord. Being senior, I am getting lower pay scale. This is my simple grievances.
Not simple, it's very complicated. You have complicated it. There are 3 OAs and 3 WPs. It is not simple. It's very much complicated by you. And you are unable to resolve. You are unable to simplify. How do you expect us to?
My lord, my simple prayer is just kindly send the petition to the special officer with a direction to
Nothing will not get that cause of action. Either you show that there is a scope for passing any order or there is no scope. There is no question of simple order reviving something which has already rested in 2013. We know how simple these prayers are. It's not that we don't know. We are asking you a simple question. You are the writ petitioner. You filed that writ petition. Pursuant to an interim order, the GO was issued on 12/10/98. Now you want another relief. What happened with the writ petition finally? You are not telling us.
kindly fix any date, my lord. I will come with.
Find out what final order was passed. Then only we can ascertain. The learned advocate.
Item number 3. Usually, millet, I do not do this, millet, but I need some accommodation, millet. I have sought for some more instructions, millet, with regard to millet, the issue that is pending before your lordship, millet. If your lordship can adjourn it for,
I am opposing.
because next week I am traveling, millet. 14th I am not here, 10th and 12th I am not also here, millet. 15th I am here. Lordship will see me on the.
I'm opposing, my lord. 2011 writ petition, my lord. We are in 2026, my lord. No new documents are issued right now, my
Not
lord.
new documents, but some instructions that I had, my lord, asked pursuant to your lordship's query on the last occasion, my lord. Those are, my lord,
What was our query?
I don't know.
the query was, my lord, well, get, my lord, the list of, my lord, how, my lord, as well. Some limitations, what was the clinching.
They don't have it, lordship. I can answer.
What is
Sorry. Sorry.
what is the order passed by the tribunal? First tell us.
There's no order of trial. Orders of the
Single bench. So what is the order passed by the land single bench?
Equality with regard to the national benefits. The issue that I
That they have come in by virtue of a
Yes,
decree,
yes,
they
yes.
cannot claim parity with the generic staff.
Yes,
This was your case.
yes.
So in the meantime, they have not got the benefit of the order.
Because we have filed an appeal. That order was passed only because it was not our petition. It was the
Obviously, it is.
petition. Since 2011, from has taken up it is since 2011. They also do not have
When the final order was passed?
into the
25.
seeking, they have waited for some time. I'm seeking only. I'm seeking only.
About 15 already died, my lord. If I wait for 15 more days, one more day will come, my lord.
Yes, heard. 2 weeks, what? 21st, we have
15 years.
free. We'll take it up at 2 then.
Lord, these are retired people, Lord. Your Lordship had fixed the matter, Lord, after taking into consideration, Lord, the mutual convenience.
28th. Then 21st. What is the date?
He's opened his case, Lord.
Yes, we remember.
Right,
Yeah.
Lordship, Lord, considering mutual convenience, your Lordship had fixed.
Well,
I'm totally sorry, I normally don't.
I understand, my lord.
Adjustments,
No,
but
we have,
Let's seek an adjournment.
we have objection, but let it come. We have fixed it after 2 weeks. Yes.
kindly, Lord, fix a time.
We have given time at 2 p.m.
Much okay.
Yes.
Grateful, my lord.
Really sorry, my lord.
Sorry, I'm sorry, my lord, because this is
Over.
untoward, my lord.
Over.
Item number 4. Dear Worship on me, my lord.
As prayed Friday.
Friday. Lord. Friday. I'm grateful to your lordship, my lord. Actually, with the grace of your lordship, I got the copy. My lord. And Judge Sahib na thakle petam Judge Sahib. Item 5.
Such a praying for short parts of our students on lead
5 to 24.
5 to 24.
Not today.
Item 25.
Not today করে দিল তো।
1 yes, serial number
5 to
5 to 24, your lordship.
You don't ask them to open the case.
No,
Why, sir?
he is not an advocate record, my lord. The another was in his court, one assisting me, my lord.
Somebody should be here. You have
Yes,
20 cases and you send someone to just seek a passover. No, the list will collapse. Nobody will be here. You are not a new counsel. 5.
Matter, my lord, I have already served all the,
We'll take up the first matter. All are same.
yes.
Let us just go through the first case.
This matter, my lord, I have challenged the order dated 19/2/2025, passed in a contempt jurisdiction on a ground that the order passed in a contempt jurisdiction is not in congruity with the original order.
The order impugned after page 267 of volume 2.
What is the date of the order passed in WPST 147 of 2009?
WPST 1409.
Please give us two dates. One is date of disposal of OA 1646.
Yes. That is at page 163 of order passed by this Honorable High Court.
Huh?
163 of volume 2.
No, what is the date?
That is of 11 August 2016.
No. OA 1646 of 1998.
Wait, wait. Okay. Kindly fold, my lord, that is the High Court's order, and the writ petition and the OA order, my lord, that is at page starts from 139,
What is the date?
20th 9 2007.
And it is at which page?
139.
And,
Of volume two.
and then WPST 147 of 2009.
163.
And what is the date?
11th August 2016.
And now let us see your order in 512 of 2020.
Right, 1 to 2020, which 2020. Which order lordship is asking for?
Your OA's order.
Kindly come to page 204. Order dated 11/3/2022.
And authorities have passed the order on which date? Where is the order passed by?
Passed by the Honorable Tribunal, my lord.
The 28/1/2025 order.
Yes, my lord. That, my lord. I tender my apology, my lord, because that I could not annex by inadvertently left out, my lord. I'm having the copy. That is the last compliance report under which this impugn order has been passed.
So you have given us a bunch. We are asking you 28/1/25 order. Where is 28/1/25 order?
Order. But 244.
28/1/25.
Yes, yes.
Reasoned order passed in compliance of the tribunal's order.
Yes, that is at page 244.
That is not the order, sir.
That is the order because
244 is not the order.
because this is the order in which in the matter of the writ petitioner, this order has been passed. Because there is a lot of matters, my lord, so they passed in the same order, only changing the dates, my lord.
So in every writ petition, in every OA, there is a different order.
Yes, my lord. The date would be different.
But this case that
Yes.
we are right now considering arises out of OA,
This is
The
my lord,
the-
pertaining to
CCPA, and
OA 328 of 2020. That is Seema Chaki versus Secretary. And this order which I have shown your lordship is pertaining to Seema Chaki. So lordship may draw the inferences on the basis of connecting the OA, CP and the order. Right. Date name. And the bunch which I have supplied to your lordship, that is the same order fixed in a last compliance, which I have handed over just now.
So why don't you challenge that order instead of challenging this order disposing of the contempt? If you challenge this order, the court can go into this issue. If you want to get embroiled in that, whether why the tribunal has not proceeded for contempt, we will issue notice.
No, because my lord, the honorable tribunal, while adjudicating the matter, has crystallized my rights on the basis of
Has
the
done nothing. It has said strictly in terms of the decision taken.
Yes,
Now they have taken a decision. You say it is not strictly in terms of.
yes,
Ultimately, the legitimacy of that order has to be adjudged,
yes.
whether in contempt or in a duly constituted application. Why you have gone to this method, we don't know.
Be- be-
See, there is a one-line rejection saying that they were not parties.
Yes.
Whether that suffices or not, that is the only issue. Whether you approach it in this way or you challenge the order directly.
Because my lord, I thought, my perception was this, because there was a strict guidelines in pursuant, and there's a doctrine of stare decisis to apply.
Notice, let them say.
Because there's a doctrine of stare, the matter has already been settled by this honorable.
So first you overcome that and then you challenge the legitimacy of the order. You can choose to do so. We'll issue a notice. Let them file opposition. The other option is you can challenge this order that we have all joined supervisors. The tribunal has held that there is a benefit of cash benefits, 3 benefits on certain years. Why we have not been given? There you have both options. We can proceed with this
Your
if you want.
lordship your lordship rightly said so, but ultimately, my lord, if I'll go by the parent order of the honorable tribunal, my lord, that fulfills my objective to the extent, because this matter has already been settled by the honorable High Court and the doctrine of stare decisis will take place. So there is no ambiguity in that.
Either you are similarly situated
Yes,
or you are not.
yes,
That's the only issue.
yes.
If you are similarly situated, whether by saying that they were not parties, a relief can be granted, denied or not. That's the only thing.
Yes. So therefore, my lord,
Therefore, in contempt, the court should go into this or it should be in a
no,
fresh proceeding.
my point is this: the contempt order is perverse, my lord. It is
Very good. So
completely
first you
illegal.
challenge the order of the contempt and then we'll go into this. Very well. Issue notice. file affidavit of service 3.
For your lordship.
Very well.
Yes.
File affidavit service 5 থেকে 24 অবধি 24 অবধি 28 সব
You
ইন্ডিভিজুয়াল
should have challenged the order. The appropriate remedy is once the order has been passed, you should challenge it. Today it will come before a single bench. The tribunal is non-functional. You want to take a more circuitous route, we are not here to advise you. You can do so. Yes, call the next.
আইটেম নাম্বার 25
respond to
Yeah.
156
অর্ডারটা চ্যালেঞ্জ করে দেবো ভিজিলেন্সের অর্ডারটা কোথায় দেখো
Yes. My lord, may I seek one time? After this,
Please try to understand.
I understood.
First, whether it is in compliance or not. Secondly, is it correct or not?
Yes,
Another option is whether it is correct or not.
yes. So my lord, that particular order, your lordship is opining the thing that the order,
You're finding it.
no, because I'm just telling your lordship in that way.
They are not.
Because I am seeking leave my lord, to just in check order pass by the respondent, my lord. To be educated, your lordship is seeking leave my lord, to challenge that
The case is
I'm seeking leave, my lord. Only grant with that leave.
the file of item number
আরেকটা দেয়া আমার
file. Actually, both things.
দাঁড়াও না রে ভাই।
All that include. All the cases, our orders are different, so we'll
Yes, I will.
indicate the order.
Yeah, I will take it. I'll take,
Give us a schedule
I'll provide the schedule.
with the case number.
Yes, my lord, I will do so.
So we'll, you give it within an hour. Just the impute not
Okay.
date, nothing else is.
Okay, I'll do it.
challenged before the learned single judge. Today, since the tribunal is non-functional, we have already decided this aspect in one case. WPSC 209, that fresh applications after the tribunal has become non-functional will have to go before the learned single judge. The matters which are pending since before, they will come here. Otherwise, there is one forum lost. So you will have to challenge it in a writ petition.
So your lordship is also heading the writ court, my lord. Perverse illegality can be adjudicated by your lordship in the jurisdiction, my lord.
We can do everything, but should we do it? That is the point. When I have myself, when this bench has decided and ruled on the jurisdiction aspect in this way, in any particular case, should we act otherwise? This issue was threadbare examined by us. An objection was raised by the state because we were taking up the matters arising out of the tribunal. We have passed a reasoned order, which till date has not been challenged. We have not been informed. In fact, every day matters WPST filed after the tribunal became non-functional, councils are coming and we are passing the same order. Liberty to assail before the bench dealing with the determination of service matters. You will have to go there. Only pending matters prior to tribunal becoming non-functional, they will come here because there the tribunal order will have to be set aside. Or the proceeding will have to be set aside under as per judgment of L. Chandra Kumar. Only division bench can hear.
Yes, my lord. In a new case, I understand, my lord. But while lordship is adjudicating two orders, the order passed in parent original application as well as the contempt reading co-jointly, then lordship will decide this issue whether this particular order passed in the contempt jurisdiction is having leaks or having in conformity with the parent order. That your lordship can adjudicate the issue, my lord.
Because we know what we can do. You need not tell us.
No, that
We want to know what you want to do. You want to continue with this or you want to accept the order, revision order? If you want to continue, we have very clearly we asked
yes,
you.
that's right.
If you want to continue with this, you may
I
continue.
thought, my lord, putting one line would be suffice.
How can it be everything in one application? How can we? That would amount to doing something indirectly which we cannot do directly. That order, if it is to be challenged, it is to be challenged before the learned single judge. How we can assume jurisdiction to take it up today? In this case, at best, we can say the tribunal was wrong.
Your lordship cannot go into the merit of the illegality.
Try to understand what we are saying. Therefore, we observe.
You will win.
Therefore, we said whether you want to go piecemeal or you want to just challenge that order. Can you please give the date?
Yes, yes, I'm supplying one.
Otherwise, I'll have to
No, no.
sit with all the files.
I'm supplying. I'm supplying.
25, I am for the future.
I'm.
My lord, earlier occasion when the matter appeared, my lord was pleased to give me direction that when the matter was been filed, on 24th July, and the bench retired on.
So we'll proceed. What is the issue? Let us see.
So this is my evidence of service. My lord, I'm being covered by my lord's judgment. My lord, this is the proceeding which is pending since 2020, an inquiry proceedings.
Since
2020.
2020, 6 years.
6 years is had been. Nothing has been furnished. Not in the meantime, I has been transferred, but I am not challenging the transfer. But the vigilance inquiry which has been done, it is pending since long, my lord, and which is affecting my mental agony. Nothing else more than that, and more importantly, my client, the petitioner over here is nothing but facing that in future if some promotion is may be given which may affect for this
Charge memo has been issued.
nothing has been issued.
Then what is your problem?
My lord, if in the future if anything happens, then he will be affected by this inquiry because
Which inquiry?
the vigilance inquiry which happened on 2020.
So that is the subject matter.
Yes, my lord, that is
My lordship, what she is calling vigilance inquiry, lord.
So just we'll hear you, please. Probably that is a pre-charge memo inquiry. That may or may not culminate into a charge memo. So why you are, how there is an apprehension today? On what basis? Show us, what is the basis of your apprehension?
my lord, kindly come to page 43. My lord, it has been said that I have been asking for bribe, which is totally a false allegation. My lord, it's not a translated copy. So it might be a problem. A complaint has been lodged by some unknown person whom I really don't know by person also, by any department wise also. So that it has been said that I am asking for bribe for getting the machineries they wanted. For which I am apprehending that in future, if I am being given some promotion or something, that might affect me.
Research.
And due to which I had also been transferred from Hooghly to Howrah, for which I am not affected much, but I'm not even challenging that also, my lord.
Which page is your prayer in the way? What is the relief?
11th onwards.
No, wayable. Page 24.
Of OA, my lord, yes.
Yes, page 24. So from where do you gather that a vigilance inquiry has started?
My lord, at page 43, they have issued a notice to me on 10th of September 2020 for the inquiry, and a date of hearing was also given on 28th September 2020. After,
Page 43.
yes, my lord, page 43. Was an inquiry over the complaint lodged by Joyanto Mollik and others by the Deputy Director of Agriculture Admin.
This is addressed to you.
Yes,
So the complaint was forwarded to you.
yes, my lord. And even a date of hearing was also given to me on 28th September.
Where is that date given?
My lord, that is on page 48.
No, that is not they are just going to visit your office. So till date, charge memo has not been issued.
No, my lord. My lord, but it might affect my promotions.
Under which provision?
My lord, in future it might affect.
Under which provision? Prior to issuance of a charge.
That's all, but nothing else, but I'm apprehending that it might affect.
In such matters, best is to let the sleeping dog lie. For 6 years, this vigilance has done nothing. You start taking up things, they will issue a charge memo immediately. Because as of date, there is no cause of action.
No
There's
cause.
some inquiry, somebody has said you asked a bribe. They gave you a letter in 2020. Last 6 years, they have done nothing.
Nothing.
So why are you?
My lord, even the based on which complaint the inquiry has been done, that is also is unknown to me. Means I really don't know the person who is that person who has.
No inquiry has been done. Inquiry will only start if a charge memo is issued.
Yes, my lord.
Otherwise, there is no inquiry in the IO. Nothing, there is nothing. The petitioner.
Your Lordship, I'm appearing for the petitioner on the item number 26 and 27. Lordship, may kindly make it not today.
Not.
Grateful, Your Lordship.
Item 28.
Yes.
Item number 20, I'm praying for short passover, my lord. Mr. Tiwari appearing in this matter, he is on his leg before court number 237. I'm praying for short passover.
Did you take consent of the senior colleague? Before mentioning, he's been sitting here. These are courtesies you should observe.
Consent. My lord, he is agree. Kindly keep it 2 p.m. my lord. Take this matter.
2 p.m. Not today. Not 2 p.m. Yes.
Item 29.
Means to the village, the earlier auction, or making respondent. We have already made service. And we have already included. But this is my affidavit of service.
Judge say এটা বেরোয়নি মেমোটা
That is the question of splitting of load. That matter will be taken your by lordship.
To avoid a higher rate.
Yes, yes.
That is your
That
case.
is, that is. Regulation 14, your lordship knows that where it has been specified. This is my affidavit of service. Track record will say that it has already been delivered. Delivered. This is the hand over the regulation. There are
Regulation 14.
regulation. It is a regulation 53 clause 14.
14, yes.
And subsequently it has initially the grievance redress office is the ombudsman, and subsequently by way of amendment, if anybody has any grievance, they can ventilate the grievance before the concerned grievance redressal officer. Against that, appeal can be preferred. And your lordship, and in this context, your lordship is well aware that division bench has already held that this matter is.
No, we are only seeing that the service was effected on 1st August.
Yes, lordship.
We have also filed the affidavit, your lordship will find.
What affidavit you have filed? For the reasons you have communicated,
Lordship,
now you have placed that on record.
lordship. In the affidavit, in pursuance to the direction given by this honorable court, we have filed this affidavit, lordship. And this letter is speak for itself that it has already been communicated to them. And they have admitted also.
How do you say they admitted?
If your lordship kindly see, in their writ petition, page 31. Page 31 in my stay application, if your lordship kindly see.
So this is not in compliance with the direction of the single judge.
No. The direction given by this single judge
Is to raise the quotation and grant
and
the
grant electricity.
Yes.
And there was no direction of filing affidavit. We didn't get the opportunity of filing affidavit. And we have preferred an appeal against that, even presuming that they never approach before the CSC authority for compliance. And on that pretext, your lordship, we preferred an appeal challenging that order, and we have already served earlier occasion. Subsequently, this court, honorable court, was pleased to direct us to make further service. We have made service, and if your lordship kindly see, so far the splitting of load is
So this order was not challenged in the writ.
no. The order passed by the single bench has been challenged in this.
No, 16/9/19, was it the subject matter of the writ petition?
No, it has not.
Is what we are.
Not has been challenged. But this is the no, ওরা চ্যালেঞ্জ করেনি, ওরা ওটা 16/9 লেটারটা চ্যালেঞ্জ করেনি, ওটাই বলতে চাই। আচ্ছা, ওরা সার্ভিস হ্যাঁ হ্যাঁ
It was disposed of on the first day.
yes
No affidavit was filed. You have said so in the appeal.
yes we have specified in the stay application also. Lordship, kindly see paragraph 4 of my stay application. Para 3, your lordship will find in para 3 also, page 3, para 3. Ma, this is the judgment. May I place it?
No, we are going to stay the order, and you service once, make one more effort to serve, we'll stay the order.
As your lordship.
Yeah. It will come, you
I'll,
will be taken up, don't worry.
I'll take the obligation.
I'm again making the fresh service. Do it. Make one more effort. If it doesn't come, then
As you lordship.
20th August বললেন তো?
Status 10ই September
20th August বললেন না?
28th August. Item number 30.
Lordship, this is an appeal filed by the state lordship. We had, applied for certified copies, which has not been received as yet. Lordship, we've established contact with the clients, but in this matter, Lordship, there is a delay and an application for stay, Lordship. I'm seeking for a week's time, Lordship, so that we can. I don't think it has been served also. The petitioner has not been served, it seems.
The application.
Yes, there is an application for condonation of delay. Nothing has happened, nothing. So, your lordship.
The application, copy of the application.
Yes.
20 August. Item number 30, 31.
Lordship, this is also an appeal of the state, Lordship. Here, the records only contain the memo, but since there's an FMA number, Lordship, then we will have to gather all the pleadings for a final hearing, Lordship.
It is not hearing.
Yes.
Immediately.
Yes, only.
The number MAT converted into FMA. MAT is their number. Then how it is converted as FMA?
What is the system? I would like to know, speaking for myself. See, the case was numbered as MAT 1279.
Yes.
It has been renumbered as FMA 1090.
Lordship, MAT is when we first file it with all the applications. And after the first hearing, it goes back for an FMA number. But either the delay is condoned, I mean, then the appeal is accepted. Therefore, since it's only FMA, Lordship,
so how it has changed? That's what we are trying to understand.
That is after the initial filing, when it comes before the court, either there is a condonation of delay or a stay, whatever it is, whatever orders are passed, it's sent down for, then the number changes to FMA.
But there's nothing like that.
There is nothing. That is why I just find the memo and nothing else, Lordship.
No, then how the number was changed? That's what we are unable to understand.
There is even no order in the, I mean, that is what I don't find. Lordship, there is a delay, I think. Is there a delay, Lordship? The stamp report, that's a delay.
No, there is no delay.
Oh, there's no delay also. So there's no delay. There's no delay, therefore it's been, it's a first appeal which has been, but they should have been a stay application or something. Only the memo has been filed.
There is nothing. Only the file along with the application.
Chief, is there any departmental note kichu nahi? Departmental note to nahi na?
Point at which the new number is given after satisfying what step?
Lordship, the appeal, the delays, the condonation of delay if there is any, or any application so that it can be accepted. So it is normally placed before the court once.
It has
It's
not
not
been.
necessary to use a stay application. Somebody may not use a stay application, but an appeal, but it's after, I mean, the first round is before.
No,
the
where
court.
is the procedure? Can you tell us where the procedure is?
And today, Lordship, then I'll have to.
Otherwise, how
I'll
this
then look up the rules.
whoever has dealt with the file,
Lordship,
he
will
how
kindly
has,
keep it, Lordship will kindly.
not today. Just we want to know. Otherwise, how he has proceeded
We'll
like
check.
this?
Yes, Lordship. Keep it not today.
Not today. So many cases we have seen where they have not done this despite the fact it was required to be done. Now here is one case where everything has been done and there is nothing, it never came to court. The nomenclature has changed everything within a week or 10 days. So where is the procedure, please?
It came before your Lordships, I think, on one occasion.
On that day, it was already FMA.
Oh, it was FMA.
Yes.
That, বাইশে কোর্টে আসেনি?
Item number 32.
Lordship, I am appearing for the only numbers 2, 3, and 5. Income tax department. Lordship, I have no copy of.
Mr. Majumdar,
Not filed, still has not been.
Same situation.
Regarding the direction in
See, again, the same thing. We are. Can you please tell us what is the procedure? When the MAT becomes an FMA, what is the flashpoint?
Normally, after a certain point of time, normally when the stay application gets disposed of,
And if there is
the
no,
tender number goes. It's the,
and if there is no stay application,
then after a certain length of time, the tender number goes.
so there is no step required to be taken in between.
No, it's the departmentally it's done. The T symbolizes the tender number. There was a prayer for release of the dues with interest.
So that
His
fair
lordship-
rent thing,
His lordship has
the
allowed.
commissioner has passed some order perhaps.
But in fact, the CPWD rates were not being adhered to by the income tax department. The entire building was being possessed by them. They tried to raise a point that I am not bound by the CPWD rates. Ultimately, this was not approved by the appeal court as well. But rather, the appeal court has come down more heavily on them by saying that if you are enjoying the entire building, how could you not pay the approved rates? So my prayer in this appeal is limited only to the interest. I have received the amount, they have acted upon this. The appeal was preferred before I received the amount.
So what is the period in question?
The period in question is from 94 to 2021. 31st of August 1994 to 30th of June 21.
Which August? 30th August.
31st of August.
Till
30th of June 2021. There has been 2 revised rate of wages in
respondent is appearing now.
I am for the union. Can come to Mala page 10 of the order, Mala. Para 38, last bill. It is, however, made it clear that the respondent will revert to institute proper civil suit.
You have instituted the suit.
Yes.
You have instituted the suit.
Then usually come to in respect of their money claim on the alleged municipal tax area and required maintenance charges if incurred by the respondents from the petitioners. If such a claim is made, the same shall be adjudicated in accordance with law by the competent civil court. Upon following due process of law, nothing in this order shall prejudice the rights and contentions of the parties in such suit, if instituted by the respondent within the period of. That is the gist of the order.
When the limitation lapsed? When the limitation lapsed?
That is the order, imposed order dated
March 23.
Yes. That I have to take instruction because just
What instruction you will take?
just yesterday I got the brief.
We are for the respond number 2, 3, and 5. The income tax authority.
2, 3, and 5. Who is 2, 3, and 5?
Income tax authority. The chief commissioner.
You are actual occupant of the premises.
They have vacated in June 2021. They were granted liberty to file a suit for recovery of tax and repairs.
Yes, because they wanted to link the two issues. They were saying this notified rate will not comply unless you discharge these obligations under the agreement or whatever. So the court said whatever is due, you pay them, and for this you proceed against them.
We have paid.
How many days after the court's order you have paid?
That we have been
The
taking
appeal
last.
No, the appeal got dismissed on 17th of May 2024. They have paid thereafter, but not I was paying for the period from 94 to 21.
So till such time it is decided by the appellate forum, can you claim an interest?
The appeal has been rejected.
In 24.
Right.
So till that date, how you can claim an interest? If the matter was already under adjudication.
That's the point. Not the court found not if two paragraphs not from the appeal court order. Please have a look at paragraph 14, 12, 14 and 15. At page 9, not paragraph 12 is bold.
না না কিছু হয়ে যাবে হবে
বুঝতে পারছি না তো ইচ্ছে দাওয়াই আমার কপি হবে
ম্যাট 1394
কপি
তো আজকে দিচ্ছি
হাতে
This order is passed in which case?
But from the principal judgment, which allowed the rent but did not permit the interest to be calculated on that.
No, in some other case.
That matter went up in appeal before the Honorable Division Bench from this judgment.
From this judgment? Then how it is back before us?
The direction to pay was challenged in an appeal by the department.
Yes.
Then the Honorable Division Bench dismissed the appeal with these observations. But paragraph 16 I place reliance upon at page 11. Thus, we find that not only
the division bench has sustained the directions issued by the writ court.
the observation that we had been unfairly dealt with for all these years, even from pillar to post, and not for this unfair treatment, what I was paying for that interim interest as well, not which we paid before the honorable single judge, but not
No,
at all.
but that unfairness has been recorded by the learned single judge also, but certain issues have been left to be adjudicated. Whether there is a claim against you, if so, how much?
His lordship held that in the absence of an agreement to pay the rent or not where the charges, one is not entitled to claim. Be that as it may, his lordship left it to the civil court to decide this, with a liberty granted to the department to file an appropriate remedy or pursue their appropriate remedy.
No, there was a claim and a counterclaim. Your claim was for rent. Their claim was for payment of municipal tax and maintenance. That unless you pay, we will not pay the rent. The court said you pay the rent. You are certain how much is payable to you through the civil court because it requires evidence. Now, if there is something due against you at this juncture, how they can be saddled with an interest? It can only be dependent upon the outcome of the court proceedings.
Now, if your lordship will kindly have a look at the other part of the order, where his lordship records that as of today, in the before the writ court, there is no evidence adduced to show that there is an agreement that this has to be paid by
Correct.
the.
Therefore, he said that it will be taken up in a suit,
Yes.
leading evidence. That issue was not gone into. So,
But please have a look at paragraph.
Are you sure that a suit has not been filed?
We have not received any notice.
The 2007 matter, my lordship. Kindly
No,
see
see,
that case.
please, why we are thinking of this? If the suit has not been filed, then situation would be totally different because limitation has already
Yes.
come in.
The court has granted a liberty that has expired.
If filed, then we don't know. So that's a relevant fact. That's a relevant fact which only they can say whether they have filed the
We
suit
have
or not.
not received any notice as of date.
Oh, that's why we are saying only they can
Only they
say.
can say.
So you tell us.
I will take
It
instructions.
is submitted by the learned senior advocate.
Item number 55.
Lord, I am for the petitioner led by Lord JP.
Lordship, I beg to appear for the respondent, Mr. Sijip
I
Chakraborty.
appear for the respondent, Lord. Am I audible to your lordships?
Yes.
My lordships, kindly allow me to address your lordships virtually today.
Yes, yes. Why not?
I'm ready with the matter, Lord. My juniors are ready with the judgments. If my allows, Lord, I will continue.
Very good.
So this is state's appeal. Mr. Singh will first address your lordships, Lord. I'll give my reply.
My Lord, may I start with the impugn order, my Lord?
Oh, please.
Not only one thing before Mr. Singh starts. The main point was whether a time-barred application could be entertained by the ICC. That's precisely the issue before my lords.
So if that is, then we can proceed.
My Lord, before that, I have to point certain things, my Lord.
Yes, you may.
Your Lordship has heard this matter previously, my Lord. My Lord will first come to the reply to the ICC notice, my Lord.
You are for the state.
I'm for the state.
So complainant has not come up against
My
you.
Lord, I will cite judgments with regard to that, my Lord. My Lord, may kindly come to page 38, my Lord.
Yes.
This is the reply to the ICC, my Lord, where the complainant has not taken this point.
Page 38.
38, my Lord, annexure C.
Yes.
My Lord, he participated in the inquiry. After the inquiry report was against him, he took this point before the tribunal first time. Now, my Lord, may I cite a judgment, my Lord, how the section 9 of this POSH has been dealt by the Supreme Court, my Lord. In the case when the complaint has been filed at a belated stage. In this case, my Lord, the case I'm referring to, my Lord, this has been filed beyond the stipulated time period. In my case, it is within the stipulated time period, but the reasons was not stated for condoning the delay after 3 months. Sir, ke diye chahiye.
You have not given the dates. You have not given us how much
My
delay.
Lord, my Lord, my Lord, my Lord, I was of the impression that your Lordship has heard. That is why your Lordship, I have to address your Lordship only on this
Give
particular
us the
point.
dates, relevant
My
dates.
Lord.
The date of the complaint. And it relates to an occurrence, last occurrence of which date?
My Lord.
Because these are facts which will not be in dispute. Based on those facts, whether what is to be done, we will see.
My Lord. My Lord, complaint is dated 5/1/2023. It is at page 25, my Lord. I'm sorry, my lord, it is page 13 in extra A.
Page 35.
My lord, page 13, my lord.
You have English version.
Lord, there is a supplementary affidavit in my lord's record, my lord, where the state has filed the translated copies. My lord takes the internal page 6 of that supplementary affidavit. Your lords will get the translated copy of the complaint, page 7. Page 6 is the Bengali vernacular, 7 is the translated copy. Now, this is affirmed by one Somnath Dotto. My lord, has got that?
Yes, we have got 5123.
5123, my lord.
Yeah, interrupted, no, let him continue.
Complaint is dated 5123, my lord. Now your lordship will see page 37, my lord. The memo issued. Grateful, my lord. So, my lord, it was not within the 90 days. It was after 90 days of the extension period. However, the statute says that within the extension period, it can be accepted, my lord, but the inquiry committee has to note down the reasons. Now, inquiry committee, fact is not disputed, has not noted down the reasons, my lord. Only it stated, my lord, that
So the last occurrence alleged is July 22.
July 22, my lord.
So by October it was required to be filed.
My lord.
And according to the act, maximum extension by another 3 months. So January. Date is not specified in the complaint.
No, my lord, date is not specified, my lord. But in the inquiry committee report, my lord, the inquiry committee has come to all these findings, my lord. I can show your lordships, my lord, what the inquiry committee has come in its findings, my lord. So may I deal with this first point, my lord?
No, why we are thinking over the issue is he is appearing virtually. Issue of identity is involved of the victim.
Oh.
That is why we are pondering over the.
Lord, I can, if my lord keeps it at 3 p.m., I can reach. Here's it today, my lord. I'm ready with the matter. I'll take half an hour only.
Let him make his submissions. You come. Okay.
Very well, my lord. I'm sorry. I was actually on my way to court. I was fearing, my lord, I'll be 5 minutes late. So, your lordship, don't get annoyed on me. I came back and sat, my lord, virtually.
Today, no, but that is the only crossing our mind. So,
Lord, we are not taking that. We are not taking names, my lord. There's no names being taken.
Still,
and the lady has not come. But I don't want to embarrass my lords, my lord. That's my first duty to my lord, so that I can keep your lordship.
Can be done with some sense of sensitivity. Then let us do it,
my lord.
Lord, allow me. I will. If Mr. Singh continues, I can reach. Or my lord, if my lord wants to keep it, my lord, Tuesday, I can finish it, my lord. I'll be there physically, my lord, before your lordships.
Let him make his submissions. Your juniors are here. They will take notes. You make your submission on Tuesday.
No, I'll reach by that time. I'm coming,
All
Lord. Very good. Let them take note. No, I'll just read your lordships.
My lord, then may I first cross this hurdle of whether the complaint after 90 days is tenable without the ICC committee stating the reasons for entertaining such complaint?